One of my subscribers requested for a video regarding how to answer questions in paper 2 of the patent agent examination, and so here is a short video about what you need to take care of. Firstly, write all the facts that are provided in the question. This will help you in clearly identifying the problem, and you will not miss any important or special considerations that need to be taken care of when responding to the question. You could also mention the facts as a paragraph or pointers, whatever works for you, but it should be clear enough for you as well as the examiner to understand. Then make a note of or at least identify the applicable sections under the Patents Act and the rules under the patent rules that will be relevant for the peculiar facts of the case as noted by you. Please make a note that under the patent rules, you must specify the applicable timelines as well as the official fee. So ideally, you should remember those. So in your answer, you first mention the facts under a heading, then the applicable sections and the applicable rules under a separate heading. So just make small statements about the applicable sections as well as the rules. Once you have specified all of the above, then apply the relevant sections and rules identified by you to the peculiar facts of the case to prepare a legal advice in the following manner. Write about the sections that will be applicable in your opinion to the specific circumstances mentioned in the question. You need not remember the exact language of the section, but at least remember the high points, keywords in the language, and the basic crux of the provision. However, ensure that you do not miss the important parts of the provision. Thereafter, you must write down the applicable rules for the sections that have been considered by you. Again, you need not remember the exact language of the rules, but at least remember the high points and the basic crux of the provision. Basically, if there are any timelines for the actions being considered or specified, then you must provide those. A typical example would be the timelines for filing a request for examination or maybe for filing an application. So in your advice, you must also provide details of the fee that would be applicable. So as a part of your preparation, if it is possible, try to remember the fee for key activities like filing an application, including that for additional claims, pages of specification, priority, etc. Request for examination, early publication, amendment on Form 13, compulsory license applications, opposition related fee, and the like. Thus, your legal advice must specify the applicable sections and rules and how those can be applied to the facts of the matter. Also, while it is not necessary, but if you remember any case law that is applicable to the facts of the case, you should specify that as well. Let us try to understand this by taking an example. There was a question in paper 2 of 2024 examination where you are provided a situation where an inventor has made an invention, and in a preliminary search that was conducted by an IPR cell, there are two prior art documents that have been cited. The question provides the details of the invention as well as the prior art in terms of the constructional features. So you are required to act as the inventor and provide a justification regarding the novelty and inventiveness in view of the prior art disclosures. So here firstly you should mention about the facts of the matter at hand, that is all the features of Ravi's invention. Thereafter mention about the features of each of the prior arts D1 and D2. This will help you answer the question easily by identifying what is novel and technically advanced. For novelty, you must mention about section 21L, which talks about new invention. You should also mention that anticipation is considered with reference to a single document, that is, no mosaicing or combining of teachings of documents is allowed for the purpose of anticipation. Thus, you cannot combine D1 and D2 to beat the novelty of the invention. Thus, each of the prior arts need to be individually compared with the present invention for the aspect of novelty. For inventive step, you may mention about section 21JA, which relates to inventive step. Basically, you must say that for inventive step, the invention must involve a technical advancement over the prior art. Here you can say that the combination of documents or mosaicing is allowed when considering inventive step. So for the inventive step aspect of the present invention, you need to specify how it is technically advanced in view of the combined teaching of D1 and D2. So for novelty, you will compare the feature of the present invention with respect to D1 first and then with respect to D2 and specify how there are different features in the present invention as compared to D1 and D2 when considered individually. And thereafter, for inventive step, you will say how the present invention is technically advanced in view of the combined teaching of D1 and D2. So even when you combine D1 and D2, the combination of features still are lacking in a technical advancement as compared to what is there in the present invention. Also, if you can and if you remember, do mention about the Supreme Court's decision in Vishwanath Prasad versus Hindustan Metal Industries, which defines the test for novelty and inventive. As I already said, this is not essential, but it may help you answer your question in a better manner. You may approach all such questions in a similar manner. You need to mention about the sections, the rules, the applicable timelines, the applicable fee, and based on that, provide your advice. I hope this will help you write your answers perfectly well in the patent agent examination. Wishing you all the best for the examination.